Here's the latest on the high-profile case, Commonwealth versus Karen Reed. The Karen Reed trial is really heating up. In the latest motion hearing, it really got intense. My last video was entitled, "Is This Perjury?" and did the attorneys know about it? Special Prosecutor Hank Brennan accused the defense of secretly preparing and paying two expert witnesses from ARCA who claimed to be completely independent in the last trial. Brennan further suggested unethical behavior on part of the defense team. Now, that is quite an allegation, and the judge was very upset about it and stopped the hearing. The hearing was very long, so I went through the whole thing several times and pulled out the clips that I thought were the most important. And you wonder why my eyes are so tired looking today. In this video, I'm going to provide you with the response from the defense along with my legal analysis. They brought in attorney Robert Alessi to respond before the judge. They insisted they were above board and did nothing wrong.
Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here.
In this clip, attorney Alessi explains the negative impact that Brennan's accusations had on the defense team.
The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. And I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared.
Now remember, these two ARCA experts were hired by the federal government as part of their investigation into the Karen Reed case. They produced a report.
So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law. Meaning, you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts. In a complete unorthodox situation. The communications start with a report from the ARCA experts and their findings and their conclusions that never changed.
After the report came out, attorney Alan Jackson reached out to the ARCA witnesses via email. As you will recall, he received a lot of criticism for these emails. Here's what attorney Alessi has to say about that.
Any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. We come to the emails, March 20. Mr. Jackson to Mr. Wolf. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial.
It wasn't clear whether they'd be allowed to testify at that point. So, according to the defense, nothing came of it. They did not pay the experts for their services, and there was no expectation of payment, according to the defense. Take a listen.
At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. So the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it."
So eventually the trial starts up. Attorney David Yannetti makes the opening statement for the defense, and he makes no mention of the ARCA witnesses at all, because at that point he's not sure whether they can testify or not, and every attorney knows you don't make promises you can't keep in the opening statement, so he says nothing about them at all.
Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying.
At the end of the trial, the defense decides they're going to call the ARCA witnesses, to everyone's surprise.
The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here.
Well, Judge Cannoni was surprised at that, so she called a voir dire. A voir dire means that both sides are allowed to question the witnesses outside the presence of the jury.
We need to get everybody here for a voir dire that can testify, yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions.
Ultimately, the ARCA witnesses were allowed to testify at trial, and their testimony was favorable to Karen Reed because, in their expert opinion, John O'Keefe's injuries were not consistent with a motor vehicle strike. So the trial ended. The next big bone of contention was this trial prep outline that Hank Brennan found after the trial was over. And he was very upset because the defense duped the government, according to him. He's claiming that when the defense made a big deal out of these 2 experts being totally independent, they really weren't, because they were prepared for trial by the defense. And I get his argument. So let's see what Attorney Alessi has to say about that one.
So they got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad. Mr. Jackson did not prepare this document, but I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, probably less than 24 hours after this outline goes to Mr. Jackson. Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that that person would have to have quite a fanciful imagination. That this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous.
Overall, they ended up blaming Dr. Wolf for sending in that trial outline that the defense never used. Now you must be wondering about that bill. Long after the trial was over, the defense gets an invoice in the mail for $23,925. Did they end up paying these so-called independent witnesses for their testimony? Let's see what they have to say.
It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? Mr. Deitch said, yes, you can pay it. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid? And after Mr. Deitch said yes, it's permissible to pay that. I believe the payment was made very shortly thereafter, maybe within a week.
So they paid the bill. But in my opinion, they're not completely innocent in all this. In hindsight, what should the defense have done? Well, they should have shared the trial prep outline from Dr. Wolf immediately. I don't think they should have paid the invoice without a retainer. At best, they should have paid the experts for their time and travel. Now you must be wondering, what should the consequences be? The Sixth Amendment protects Karen Reed's rights to present a defense, which includes calling witnesses and presenting her case with attorneys. Overall, in my opinion, these allegations made by Brennan are just not egregious enough to warrant removal of any of her defense attorneys. With that said, this is still beneficial for the prosecution's case because now Hank Brennan can raise all these issues during cross-examination in the next trial. And let me tell you, he's very good at it because I watched him every day during the Whitey Bulger case. With that, so what's next? Well, the defense just filed a motion to dismiss the case due to prosecutorial misconduct. Stay tuned for my legal analysis on that one. And of course, thank you for listening. And if you wouldn't mind subscribing, that would be great. See you next time.